Swayam Prabha. Digital India. Educated India.
Through Lawrence Lessig today, we will take a closer look at the governance of copyright and its implications on creativity and innovation. Okay, as we have seen that as technology changes, technologies of communication and writing changes, it also brings about corresponding changes in the way creativity operates, in the way genres develop, in the way writers' imagination work and reference the world. And copyright being a specific legal form of mechanical reproduction has its implications on creativity. Now, as I have been trying to argue that copyright is a legal expression of the mechanical reproduction of art. However, with the coming of the digital reproduction, various publication houses, big publication interests seek to keep copyright in place in the for the sake of maintaining intellectual property, the sanctity of intellectual property. And what we are going to do over a few lectures is to actually examine this, examine these specific claims on the basis of which the edifice of copyright is made to rest. All right. So, let us begin. So, what Lawrence Lessig, now interestingly Lawrence Lessig's book which we are referencing here, Free Cultures, is freely available. It is published on with a Creative Commons license, and it you can actually access the book online and read it as you whenever you want, and that is one great part. One of the difficulties of a course like this is that the reading material has to be organized by the student, and in this particular case with Lawrence Lessig's reading, it is freely available. So he says that there is what he argues is that there is a war. That's the kind of emotional pitch that he places. And what is this war? This is a war which has been launched by the content industry. Content, as we can see, is the flip side of technology, that if there is a particular technology for that particular platform, for that particular machine to sell, you need content. So, if there is a video game player, there has to be enough video games for people to keep buying it, or if people are going to buy high definition television sets, there needs to be enough content for people to be able to be incentivized enough to buy it. So, therefore, then if companies can build a certain kind of a synergy between the two, between hardware and software, then they can kind of capture the market. If I can incentivize the buying of hardware through a content. So, in order to access a certain content, you need a certain hardware, but once you have the hardware, you can only access one kind of content from one particular provider. So, the two sort of that particular synergy can help create monopolies in a particular, and we have already seen how within the digital media specific platforms create genres. Genres are not do not begin with what we have historically thought of content writers or authors, poets. but it also begins with the software designers. And I acknowledge that the software designing is part of the creativity. One needs a certain kind of collaboration between the writer and the software designer, between the artist and the software designer, to be able to create necessary platforms for innovative content. However, one needs to understand that a lot of this is directed by the needs of profit, by the needs of the corporate house, which is investing in that particular kind of content. And therefore, the content industry, who are the constituents of the content industry? Primarily big producers of films, film producers, television studios primarily, or it could be audio labels. So games providers, games designers and distributors. So they are the ones who have launched this war, according to Lessig, and their purported motive in the war is to fight piracy and to protect property. And when they say protect, it actually means intellectual property. What comes as intellectual property? Property means that specifically referring to private property, that a certain thing is owned by a specific person or a specific corporation. All right. And what are the consequences of this war, according to Lawrence Lessig? He says that this kind of a war, kind of of intellectual property launched by the content industry, constrain creators, because what it constrains is that it prevents writers from reframing stories, capturing stories and sharing stories. And therefore, so if you take an idea from somewhere, reframe it, and you take a joke from somebody and sort of add a little layer to it and make it funnier, or make it more relevant to a particular occasion, that is fine. But if you are doing it in any machine readable format, in any particular act of reproduction, whether digital or mechanical, that becomes illegal and you cannot do that. So he gives an example that storytelling is presumed to be legal, but and never has a painter worried about whether his work of painting infringed on someone else's work. People get inspired by other people's works and produce a certain kind of painting, but you cannot do that. Cannot do that in the digital universe. These will be referenced, and you can, if anybody does it, they are likely to face a legal suit, depending on whose work is being violated, so to say. All right. So what we can see is that he says that this has always happened. This kind of sharing, this kind of reframing of work has always been the case of creativity. But however, the way digital technologies are framed, the law is framed for digital technologies are very different. He says that because with the digital technologies operate slightly differently, because there is he talks about greater fidelity. There are two important things. One is that with the digital technologies, trackability is a lot more. One can have a sense of what is happening across the network, and it could be a very vast network, geographically diverse sort of network, and one can have very easily run a certain program to be able to gather the necessary information, look at matches. For example, if you take a search engine, you can find that search engines can very easily sort of match even images, right? And more sophisticated programs will be able to actually track video files, audio files, and look at similarities across a network. Much more difficult to actually track this kind of piracy kind of similarity in the physical world. So he says that because there is this greater degree of fidelity, it is easier to actually match. The other point also is that fact that in the digital content, every copy has a far greater resonance, far greater is almost exactly the same as any other copy. In fact, there is no distinction between what one can call an original and the copy, because both remain exactly the same. So if we can remind ourselves of what Walter Benjamin's discussion, where he talks of authenticity, the fact that in mechanical reproduction, every subsequent edition of a particular work, there is a deterioration of content. If you take a photocopy machine and you keep photocopying from one generation to another, one particular copy to another, progressively it gets lesser and lesser clearer. The copy bears lesser and lesser resemblance to the original. In fact, very often you can actually say which one is the original and which one is the copy, without much difficulty. But as technology grows, we find that distinction becomes lesser and lesser, and copies become much more have greater sort of fidelity to the original. So as technology grows, and that sort of comes to another point in digital media, that there remains no longer any distinction between any particular generation of copy. Every copy is exactly equal. So that is one of the arguments that is used, that in order to prevent sharing through copying. The other point, of course, is that within the digital universe, you cannot actually enjoy anything. You cannot read anything without actually making a copy of it. So there are extraordinarily diverse formats here, and normally it is that these infringements can be tracked with ease, he says, and what Lessig really gets at is that law remains very unclear, and he talks about a certain legal environment that pervades in today's world, and he is primarily referring to the US legal environment. But I wouldn't say that actually is very much different within India. It actually depends on how good a lawyer a particular party has to be able to push through a particular decision, because the legal process doesn't only depend on the letter of the law, but the interpretation of the law, and the interpretation of the law is sought from multifarious case studies, and a better lawyer would have a larger team and would of course be more diligent to be able to look through case studies which support their client's case. So therefore, only those who are able to pay for better lawyers can actually exercise this particular right. So now what happens is that if someone wants to use something, one has to make sure that there is a certain permission process, and that permission process often gets it is not a straightforward permission. It is a permission which is paid for. And very interestingly, if you are inspired by a particular artist's work, if artist B is inspired by artist A, it is not enough that artist B talks to artist A and artist A says, fine, go ahead, use it. I am very happy that you're creating new work based on my work. It doesn't happen, because artist A no longer owns her work. She has already sold the rights to a publishing house. to a content provider, and so therefore artist B has to talk to the publisher of artist A, and very often these corporate houses will ask for money, and which the artist B may not be able to afford, or it becomes prohibitive, and therefore it becomes very difficult. However, if there have been many cases, many instances, and we know that in our country as well, that for example, songs are simply lifted from folk tunes and used in movies, because the songs are probably owned by the community, and the community is not empowered enough, does not have the legal wherewithal to be able to contest and this kind of action by any particular recording label or film studio, or very simply, a particular artist may not have the kind of monetary backing to be able to take on the might of a large publishing house, or very simply, if someone raises a voice, a certain amount of payment can be made, but that is only if somebody raises a voice. As a matter of fact, it does not happen. So what Lessig is really talking about is a very lopsided kind of legal structure, which is heavily weighed towards those who are able to get better lawyers, right? And these boundaries remain very unclear as to what is legal, and one does not know that there are he says that there are astonishingly broad regulations that pass under the name of copyright. One really there is great uncertainty in law, so one really does not know. And another important aspect is that there are constantly newer technologies which are coming about, and how the law should actually apply to specific new technologies, one really does not know. And he sort of discusses a couple of cases. He says that and where the law is very contradictory. For example, he looks at the development of photography, and when personal photography starts developing, what happens initially in the days of photography, people would take family portraits and other special occasions, which are obviously commissioned works. But later on, when the camera becomes extremely mobile and portable, people take it around and take pictures of various public places, and in a touristy sort of way. And the question emerges: does the person have a right to? Does the owner of a camera have a right to shoot any particular image anywhere, or does permission have to be taken? And the courts rule that that it is perfectly fine, but which is, however, not carried on to the case, as he will discuss in the case of internet radio. That is not something that the similar law does not pass on. It is looked upon as a violation. To take on specific content and circulate them on internet radio is looked upon as a violation of intellectual property. So there could be, and he please go through this book when you can. He looks at these kind of contradictory legal case studies, and where decisions have been contradictory vis-a-vis different kinds of technology or different kinds of situations. All right. So and what he also suggests is that when he looks at these specific cases, is that in cases of where there is violation, where it is found, the punishment, the penalties that supposed violators have to pay seem to be astonishingly harsh. So Lessig discusses one specific case. There he actually discusses many cases, but we are going to look at a very specific case of a particular case where Jesse Jordan was charged with $98 billion for creating of search engine for song sharing. So, what had happened is that and that sort of gave rise to this file sharing mechanism of Napster, all right. So, what happened there in that specific case? So, the situation was that there was a particular university where students were sharing MP3 files among themselves, and they would be doing it physically. But what one enterprising student did was to create a certain search engine which allowed people to sort of figure out who has which particular songs on their machines across the network, university network, and that made sort of file exchange a whole lot easier, something that was happening much more efficient, and something that was happening across the university anyway physically. For those of you who are who grew up in the 1980s would remember that people would actually take each other's audio cassettes and record specific songs and make compilations. So, in fact, there would be particular shops who would actually create these specially recorded cassettes on order, and that worked out much cheaper because you got exactly the songs that you wanted. So, something more efficient than that in the form of MP3 was created. What you need to understand is that the creator of the search engine never actually put any song on their own computer. It was just a search engine which let students see who had which file across the network. And here the Recording Artists Association sort of hauled up and issued a fine on the creator of the search engine for copyright violation, whereas actually if you think of it, there was no specific copyright because this person hadn't stolen any file at all. But what usually happens is that this is a strategy that is undertaken by recording labels or large content providers to actually create a very large sort of exemplary amount of penalty, to charge a very large exemplary amount of penalty, so as to create a kind of an example before anybody else who might violate. Because though these kind of violations are trackable, these violations are rampant, and therefore it is very difficult to actually take action on every single cases of violation, because the technology is available to everybody. All of us can be pirates on the internet, and because the technology is so easily today the copying technology is so much easier. You know, if you look at the 17th century, for example, in order to pirate a book, one had to actually have a physical setup of a printing press, which is capital intensive, which is very expensive, and one cannot run away overnight with the printing machine. The printing machine is there as an evidence. The paper and the ink and the printed sheets will all be there, and it is very difficult for this person to escape. Whereas today's day and age, almost, and in fact in the case of a photocopy machine also, you know, that also requires a certain amount of money. You can, not every household could have a photocopy machine, but today everybody has a mobile phone. We can easily scan any particular book or whatever that we want, and there is and so the ease of the technology makes copying much more easy, as copying becomes easier, it so therefore laws and the penalties increase in size, increase in severity, because in order to simply dissuade people from using the technology that is very accessible at all. All right. So in this he argues that this sort of works against creativity and a certain kind of this regulation what is sought to be put in place to sort of prevent competition. There are people within the free market who the advocates of free market oppose regulation, and it creates a particular situation where innovators can are only safe if you sort of seek permission from the person who has been the last generator of that particular content. So very interestingly, if there is a Shakespeare play, you can keep borrowing from it, but however, if there is a film which has been produced on a Shakespeare play and you want to sort of use a snip of it for any particular creative act, let us say for this course, one cannot do that without permission. Now the person who has created the film, produced the film, did not seek permission from any from Shakespeare or his heirs, right. So so that is freely available. But however, if one uses the film to sort of access Shakespeare, then that becomes a violation. So he says that therefore it is only safe, innovators find it safe that they get a sign off, they get a permission from the last generation's dominant industries, that is these large electronic media companies. And this and he says that the uncertainty that is there, that uncertainty that he discusses in the law, becomes a liability, because it creates kills competition. Artists are unsure whether they will get permission or not, whether a particular usage is legal or not. Do remember that one of the features of copyright law is that one should be able to use use certain snippets of work which is for fair use, especially for educational purposes. Fair use. In fact, some of you may remember the famous case of the Delhi School of Economics photocopy shop, where this particular shop was charged with violation by several large publishing houses, for creating course material, photocopying course material. But the courts in India have adjudged that for educational purpose, specific amounts of copies can be made, and course packs can be created, and that is perfectly legal. Now, if we were to create a course pack for this particular course, which is an online course, for example, now one does not know how that will be interpreted, because there is a change in technology. So, to be on the safe side, one does not share anything, because one does not want to get into the kind of legal quagmire, and therefore it sort of makes it less vibrant, and it sort of kills creativity. And what is interesting that Lawrence Lessig also suggests is that if, as we have already seen, that this kind of atmosphere of an intellectual property is a creation of a capitalist print production system, the argument is that capitalism thrives on competition, that it is competition that will push prices down and make supplies available to the larger population. But however, what we are seeing in the case of the way copyright is being administered is that publishers are seeking to create monopolies and actually kill competition, and it harms creativity. So, this is what Lawrence Lessig argues. Now, what happens with the internet is that the internet I mean these kind of case studies which he undertakes have always been there in the case of even before the internet with the electronic media. However, with the coming of the internet, the range of copying and the efficiency of copying increases exponentially. You would remember that one of the ways in which movies would be pirated would be someone sitting in the first show or the first day of a particular release with a camera and actually recording off the screen, and that was the way the piracy would happen. But that kind of piracy would only happen would require a geographic proximity within which that piracy actually spreads, right, because whoever records that particular film then distributes it within a particular geography, as well as the film must be released in the geography where in the place where it is being, the pirated copy is being produced. But in the case of the internet, one can be sitting in any corner of the globe with a proper internet connection, and one can engage in this act of piracy. And though it is trackable, it becomes with the amount of violations, it becomes more and more difficult to do that when the incidences are very large. It requires a lot of inputs, lot of surveillance inputs to be able to actually figure out how to figure out who is violated. The exact cases of violations have to be figured out. Now, it discusses a few other examples. It discusses the example of internet radio, which I had referred to earlier in this lecture. Now, internet radio now is a very important innovation. There are these internet based radio channels where one can listen to various kinds of music. Now, what are the advantages of internet radio over conventional AM or FM radio? So, it has a wider range, the bandwidth, I mean there is no restriction of bandwidth, because remember within either AM or FM radio there is a certain bandwidth with which one can play. So, specific bandwidths would have to be auctioned off, and whereas in the case of internet radio there can be any number of radio stations, and that bandwidth is not a problem. The potential audience is the whole world, and it is more competitive certainly, and most importantly there can be niche stations. So, in the case of an FM studio, for example, if there is a particular genre of music which some people like, but it is not very popular, then it is a dilemma for the FM recording station as to whether or not to actually allot any particular time to that particular genre. Whereas, because they will the FM radio or transmits within only a certain geography. However, with or AM radio would transmit also to a certain geography, depending on the particular frequency that is used. Certainly, with shortwave there is a fall in quality. So, therefore, the good quality high definition audio would have a very restricted geography if transmitted across the FM. But with internet radio, that range is the entire world. So, within a limited geography, the FM will find only a very few number of people who would be interested in a particular genre of less popularity. But internet radio would be able to find a far greater number of people across the globe, and therefore, it would become more viable. And if it is in the case of paid customers, paid listeners, they would be able to pull it off monetarily. Now, what happens is there was an attempt to control the internet radio. The similar kind of attempt was made to control the FM when it came about. So, there was so therefore, one would think that this is an open and shut case. If you can if transmitting songs on FM radio are not looked upon as violations of copyright, then transmitting songs or material on internet radio should also not be looked upon as violations of copyright. So, but the RIA raised an objection to this, and so and the legal clause was that was put that any internet radio transmitter broadcaster has to pay a certain amount the artist for each broadcast. Now, in FM it is not thought of, it is a general license for the song, whereas here on the internet it was thought that you had to pay for each single broadcast. Additionally, the host broadcaster had to was required to collect a host of songs for a host of data for each listening transaction. So, each person who is listening to it, you have to collect a lot of data on that particular person, makes it all the more cumbersome. It actually violates privacy clauses. So, when the lawyer asked that, so the judge was curious, and the judge asked the RIA as to why are you asking for these kind of regulations to be put in place. He says that their explanation was, we do not really model this industry with thousands of webcasters. We think it should be an industry with 5 or 6 or 7 big players who can pay a high rate, and it is a stable, predictable market. So, there goes any argument about competition, and the fact is that here is a technology which can make a niche market possible, a global market possible, but specific content providers, the content industry is trying to frame the scope of the technology. The technology can be far more democratic, far more liberal, but it is being framed in a very restrictive sort of way, where there are only a few big players, stable, predictable market, which means that is trying to sort of do away with any kind of competition. So, what Lessig argues is that it does not matter as to what kind of what the law says. It is how the law can be interpreted by paying very powerful lawyers, and if you have powerful lawyers within your workforce, then you can sort of carry off the kind of decision that can be made. This may not be true. This is not to criticize the courts and say that the courts do not make proper judgments at all, but across this is Lessig's argument is based on his study of a numerous number of cases, specifically on the issue of intellectual property. And what he argues is that this kind of over regulation, this desire for this move towards a kind of over regulation sort of stifles creativity, and it wastes opportunity for a kind of democratic democratization of creativity that digital technology enables. Today, a lot more people can be creative because the creative technologies are really available with a whole lot more number of people. Today, YouTubers and people run their own studios. Creative artists can create their own studios, right? So, you really do not need very hi-fi recording equipment. I mean, if one thinks of 20-25 years ago, recording this kind of a lecture would have cost a huge deal more. Today, it costs other than the cost of the personnel, the equipment costs have become a whole lot cheaper, right? and a slightly less sophisticated kind of recording would cost even lesser. People can use a single mobile phone to actually edit video as well, so roughly a good amount, good quality videos that can be produced. For recording songs, one does not need much. I mean, the number of podcasts have grown tremendously. So, there is this extraordinary opportunity for creativity which could be there, but it is the kind of copyright laws which are there, which are actually seeking to stifle. And he says that it criminalizes people, and he looks at examples of America. He says that in 2002, 43 million Americans downloaded music. So, that means about 20% of America are actually criminals in the eyes of the law. So, it is similar to the argument being made by Stallman, that if there are open licenses, that would the open licenses would mean that one does not have to do illegal acts, one does not have to use pirated software, pirated either word processing software or photo editing software or various other kinds of software of daily use, simply because one needs to use a particular platform, and that is copyrighted, that is protected by intellectual property laws. So, open content licenses can actually make not force people to engage in illegal acts. So, now and really so what he argues is that there is really no need to actually criminalize larger numbers of people. And if there is, and one of the arguments that is made is that can artists be paid without locking down content, and because that would bring a greater degree of freedom. One of the principal arguments that is made by the votaries of strong copyright intellectual property laws within the content domain is that this is in order to actually pay for the artist. But it would or encourage the artist to, and that has historically been the logic of copyright. But this may not be the only way. This kind of very strong copyright laws need not be the only way in which artists can be paid. It was not that artists did not get paid for their work or did not survive for their work before the coming of copyright. With the first Copyright Act really comes about in the early 18th century. People have been creating before that, and they have survived. They had survived. So, is there within the digital domain, is there a way in which artists can be paid for their work without locking down content? And so, that is a question that he asks, and he says that the various kinds of regular daily actions of people, like compiling a playlist of one's CDs. So, if somebody takes a CD and just makes puts the song on the hard drive and it lies there in the network, then that would be looked upon as a violation. So, for example, in a particular case, he suggests that if a student has been gifted a CD by somebody, and the student takes that CD to the university computer and just puts it in, and the university computer then is able to access that CD, and the student actually is listening to the songs, but because it appears on the network, it becomes a violation. And moment it becomes and then these large content providers have protocols with institutions, and the university would be forced to reveal the identity of this particular student, and the student will get sued by the industry. So specific and the law is such that people who seem to violate copyright law have very limited liberties. So and the RIAA or organizations like that force the ISPs to reveal the identities of violators, and this is extremely dangerous for in a kind of turn for the kind of sharing that one can locate with, one can identify with friendship, okay, or normal human behavior of sharing good content, good ideas with others, and that because much of the content remains in the digital format, that kind of sharing immediately becomes criminalized and possibly illegal. And so what he is suggesting, and this kind of copyright regime actually works against the traditions of creativity. Two, it also works against the specific kind of need for energizing or encouraging creativity, right. Creativity has always historically operated through sharing, and it is human action, normal human tendency to share with fellow human beings. There is no need to, he says that it is very unfortunate that sharing is being criminalized.